Today, we will cover the six most important things to know about redomestication. That is the legal process of moving an existing business, which may be an LLC, corporation, or partnership, from one state to a new state while maintaining the same federal employer identification number, business credit history, bank accounts, and contracts. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Redomestication is an intricate legal process which serves as a critical opportunity for businesses seeking relief from the escalating challenges posed by high tax and heavily regulated states, legally enabling relocation to more favorable jurisdictions such as Florida or Texas. However, mishandling this nuanced procedure can result in severe complications, including IRS audits, substantial fines, or the inadvertent termination of your business together with its EIN and contracts. What follows in today's presentation is an examination of some of the most vital aspects to understand, as well as information on how to avoid some of the most common pitfalls that have undermined numerous DIY attempts and the efforts of less experienced attorneys and CPAs. Let's start with number one, a basic working definition. Redomestication is the deliberate, structured legal relocation of a business entity's domicile, for instance, from restrictive environments in Delaware, California, Illinois, Maryland, New York, and other states to more permissive ones like Florida or Texas. This process is far from simple administrative paperwork. It is far from a check the box exercise. But when performed correctly, it safeguards and maintains the existing federal employer identification number, as well as your existing contracts, business credit history, and most importantly, the entity's ongoing legal identity. In contrast to mergers and dissolutions, which often incur significant tax liabilities or necessitate starting anew with fresh contracts at a fresh EIN number, or foreign qualification that perpetuates undesirable entanglements in multiple state bureaucracies, redomestication is distinct insofar as it ensures operational continuity and continuity of the federal employer identification number. Nevertheless, implementation requires meticulous and consistent accuracy, including, among other things, developing and formally adopting a legal plan of conversion, filing articles of conversion and formation or articles of domestication and incorporation, as the case may be, and obtaining unanimous owner approval, which in the case of an LLC is the unanimous approval of the members, and in the case of a corporation, the unanimous approval of the shareholders. Any deviation in sequencing could lead to serious and, in some cases, unfixable legal and tax complications. Number two, alongside the perils of an action, let's talk about some of the incentives in target states. Florida and Texas are structured to support business viability, featuring no personal income tax, as well as exemptions from franchise or income taxes for the majority of entity types, coupled with reduced regulatory demands, robust asset protection, and homestead measures and advanced digital administrative systems that minimize inefficiencies and welcome new businesses to these states. Reports indicate that entities departing from tax-intensive regions like Illinois or Michigan achieve annual savings in the thousands and sometimes tens of thousands of dollars by relocating to more business-friendly states. Yet remaining in such areas exposes operations to intensifying fiscal pressures, unpredictable legislative alterations. Just look at what's going on with the so-called exit tax in California, and cumbersome compliance requirements that could gradually diminish profitability or precipitate closures during future recessions. All the more reason to locate to a state that values your business and your citizenship. The increasing volume of redomestication inquiries fielded by my law firm reflect widespread apprehension among business owners about jurisdictions perceived as adversarial to enterprise, rendering redomestication not merely advantageous, but potentially imperative to prevent competitive disadvantage. How about number three? A primary strength of redomestication lies in its capacity to preserve uninterrupted functionality and operations, thereby eliminating the need to acquire a new EIN, rewrite contracts, open new bank accounts, or hastily revise supplier agreements and permits. Now, this continuity extends to maintaining litigation records and stakeholder relationships, which is indispensable for mature organizations, particularly organizations that have been in existence for some period of time, where disruptions could erode client or vendor trust or inflict reputational harm. Consider the instability signaled by a flawed merger, halted activities, bewildered partners, and erosion of confidence as customers scrutinize perceived instability and discontinuity. By avoiding such turmoil, redomestication, on the other hand, protects against these threats. However, failing to pursue it may allow a detrimental state environment to stifle expansion, transforming manageable challenges into severe survival risks, while others migrate to superior conditions, or at least states that are more welcoming to entrepreneurs. Number four, redomestication surpasses the perpetual commitments of foreign qualification, where ongoing submissions and levies in the original state can endure indefinitely. All the time I speak with people who conflate redomestication with foreign entity qualification. Foreign entity qualification is like dialysis, and redomestication is like getting a wonderful kidney transplant. Maybe that's a bit of an exaggeration, but hopefully it gets the point across. Redomestication, unlike foreign entity qualification, decisively terminates those ongoing obligations by a mechanism of statutory conversion, thereby alleviating the load of repetitive annual reports, franchise assessments, and in many cases, tax filings. Such streamlining can reclaim considerable administrative effort and reduce your annual financial outlays on tax preparers, but errors in execution amplify uncertainties. Partial disengagements might invite concurrent audits from multiple authorities, conflicting rules, or unforeseen obligations from the prior jurisdiction, evolving an intended emancipation into an extended legal entanglement that depletes assets and fosters ongoing skepticism regarding the enterprise's sustainability and value as a going concern. All the more reason to adopt for redomestication over dissolution, merger, or foreign entity qualification. Now, reason number five, or I should say aspect number five, really it's all blended together at this point, but I hope you're finding value in this information. When executed properly, redomestication qualifies as a non-taxable event. Let me say that again. When handled properly, redomestication is a non-taxable occurrence pursuant to the Federal Internal Revenue Code, thereby avoiding the substantial capital gains or transfer taxes associated with dissolution and some mergers. This approach bolsters the fiscal integrity of the business without activating IRS alerts, yet the element of doubt is pronounced. Inaccuracies in scheduling, sequencing, or the preparation and filing of paperwork could provoke rigorous examinations and sanctions that could seriously impact the operational and financial viability of the business. This is why it is so important for you to work with an experienced attorney when handling a redomestication. Amid the present unpredictable taxation framework characterized by heightened federal oversight, a single mistake in a redomestication gone wrong may extend beyond mere monetary losses to undermine credibility with business partners and customers, thereby deterring prospects in a fiercely contested arena. Number 6, far from a self managed endeavor or weekend project, the redomestication process is an intricate maneuver implicating state and federal law, which renders amateur efforts highly hazardous and inadvisable. Complex documents must be formulated and filed correctly the first time, lest they invite unwanted attention from the IRS and state taxing regimes, or even worse, inadvertent terminations. These are issues frequently encountered in remedial scenarios where I am brought in after the fact to clean up the mistakes of a DIY effort gone wrong. These corrections invariably demand exponentially greater investments of time and money, often exceeding $15,000 and sometimes even reaching six figures, compared to retaining me or another competent attorney at the outset. For that reason, I cannot overstate the importance of retaining counsel experienced in this unique area of law. It's a little bit like trying to do brain surgery on yourself in the kitchen using a butcher knife with no anesthesia if you try to go this alone. And if you think that's an exaggeration, well, you've got an interesting path ahead of you. But to conclude, redomestication represents a valuable mechanism for addressing contemporary business adversities. Yet its elevated risks necessitate the involvement of experienced professionals to mitigate the uncertainty and hazards inherent in procedural missteps. If you have questions regarding redomesticating your existing LLC or corporation, please use the link in the description for more information on this process and to schedule time for us to chat about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.